Thank you. To set just a brief bit of context for my reflection today, a few years ago, some clever, I guess I best put it, elder law attorneys, a profession that I was in before I entered the ministry, developed the idea of having April 16th be something called Healthcare Decision Days. Something having to do with death and taxes, I guess. The notion was that on the 16th or someday shortly after tax filing would be a day around the country to promote people to do advanced medical directives. And that's why I have selected today as the day to present this, as about as close to that day as we're going to come. This is an important issue. I would just mention that after the service today, after coffee hour, if anybody would like to join us, I'm going to do a little more in-depth facilitation of conversations relating to end-of-life planning, and I invite you to join us over here because we will be showing some things up on the video screen. To start this morning, I would like to share a story with you, a story of Stephen and his great-aunt Jane. Both of these are fictitious names, though some of the subject is fairly obvious and fairly consistent with what many of us have gone through. Jane was Stephen's mother's aunt, and after his mother's death, Stephen agreed to help care for her, including acting as her power of attorney and the executor of her estate. Now, Stephen didn't know Jane very well, and so he attempted to engage her in a conversation about her philosophy of life and her wishes related to health care, especially end-of-life care. Although Stephen raised these questions from time to time, he could never really get Jane to talk about her health care preferences. She always said that other issues were more important. While he would see Jane from time to time at family gatherings, they were not close, and so had never had any real in-depth conversations about her wishes. Then one morning, Stephen got a call from the manager of the apartment building where Jane was living, who told him that she had been found unconscious in her apartment and taken to the emergency room of a local hospital. He rushed over to the hospital, found her in the emergency room, intubated, had the breathing tube down her throat, and unconscious. He talked briefly with the doctor, and they decided Stephen should come back to the hospital later in the day unless something changed before then. And so he came back at about 5 o'clock. Jane was still in the emergency room, still intubated, still unconscious. He talked further with the doctor, who had asked Stephen if he would consent to the removal of the breathing tube. When he asked the obvious question of what would happen, the doctor said it was likely she would die. Now, needless to say, this came as quite a shock to Stephen. He told the doctor he really didn't know what Jane's wishes would be in this situation, and he needed to give the matter some thought. It was agreed that he would come back the next morning. He went back home, very troubled. He knew a number of family members and friends who he thought might know her wishes, and so he made several calls that night and did not get a whole lot of sleep. But he went back to the hospital the next morning, fully prepared to authorize the removal of the breathing tube, even if she were to die as a result. Well, when he came back, she'd been moved to the ICU, and so he went to her room. There she was, still intubated, but awake and very alert. Then they removed the breathing tube without incident, and as you can imagine, very soon thereafter, Jane and Stephen had that conversation. Now, to be fair, they had done almost everything right. She had prepared a power of attorney for health care. She had picked an agent that she trusted, and somehow the identity of the agent had been communicated to the hospital. And Stephen even had a copy of the power of attorney document. But they missed one very big part of the process. They had not had a detailed conversation about her views and values related to health care and what kinds of decisions she would want made if that eventuality arose. Now, Stephen had tried to have the conversation, but it never really reached the top of Jane's list of priorities. Her situation was not unusual. In a 2012 survey of California residents, 60% of the respondents said that making sure their family was not burdened with difficult health care decisions was extremely important to them. Yet only 56% of those same respondents had actually communicated what they wanted to their family. In short, most had not had the conversation. Now, this whole need to talk about decisions related to health care, especially those decisions having to do with what we call end-of-life care, is a relatively new phenomenon in historical terms. In 1900, the average life expectancy in the United States was about 41 years. By 2000, it had increased to 78 years, largely due to the reduction in childhood mortality and the development of antibiotics. In addition, by the second half of the 20th century, medical equipment and procedures that we take for granted today, CPR and defibrillators to restart hearts that had stopped beating, ventilators to assist damaged or diseased lungs in breathing, feeding tubes to provide nutrition and hydration to patients who could not eat or drink on their own, and various chemical and radiation treatments to fight deadly cancers, all of these have kept the Grim Reaper at bay. However, as is usually the case, these miraculously new devices and treatments have raised a whole host of new and complex legal and medical and ethical questions. First of all, we are living longer. But this often means that we are living with greater degrees of incapacity. Put another way, the good news is that we're living longer. The bad news is that the longer we live, the more likely it is that we will manifest Alzheimer's disease or one of the related categories of dementia, those illnesses that cause physical deterioration of the brain. If we should reach age 85, 1 out of 2 of us will develop dementia. And what is more troubling is that persons over 85, sometimes called the oldest of the old, is the fastest growing part of the population, and they are overwhelmingly women. Our medical technology has also allowed us to save persons with traumatic brain injury from accidents or strokes, but it hasn't yet taught us how to repair the damaged brain. According to the Global Coalition on Aging, there are over 36 million cases of Alzheimer's disease worldwide. If we don't make significant research progress, by 2030 this will increase to 66 million cases, and by 2050 to 115 million cases. By 2050, the cumulative cost of the care and treatment of Alzheimer's could be as much as a staggering $20 trillion. And most of these cases will be persons unable to make their own medical or other decisions for significant periods of their lives. As is often the case, society, religion, and the law have been scrambling to catch up with these scientific and medical developments. Late one evening in 1983, a young Missouri woman, Nancy Cruzan, was driving home at night. She lost control of her car, was thrown from it, and suffered a severe traumatic brain injury. She was saved by the paramedics in the field and rushed to the emergency room of a local hospital. At some point, though still unconscious, she stabilized medically, and without a lot of discussion, a feeding tube was implanted in her stomach. She remained in the hospital for a period of time and was eventually moved to a state rehabilitation hospital where she didn't improve. While she was able to breathe without assistance from a ventilator, she did not regain consciousness and was unable to take food or fluids by mouth. The feeding tube kept her alive. But after 4 years in this condition, and having come to the conclusion that she was not going to get better, and believing that Nancy would not want to continue living in this condition, her parents, Joe and Joyce Cruzan, approached the state hospital with a request to remove the feeding tube and let her die. This was new ground for everyone. In the 1970s, the New Jersey Supreme Court had ruled that an individual, in this case Karen Ann Quinlan, had the right to refuse unwanted medical treatment, including life-sustaining treatment, and that right could be exercised by a court-appointed guardian. In the Quinlan case, the procedure was the ventilator that was breathing for her. The court ordered the disconnection of the ventilator, but because she was weaned off it, what's a fairly common practice today, she continued breathing and lived for over another 10 years, having been kept alive on a feeding tube. Nancy Cruzan's case was a little bit different. She was in a condition known as a persistent vegetative state. In essence, while her higher cognitive functions of the brain were irreversibly destroyed, her brainstem, which controlled the automatic functions of the body, including breathing and heartbeats, was working so that so long as she received nourishment and fluids, she would continue physically living, albeit with no ability to recognize or interact with other people or her environment. Because of the legal novelty of the case and the emotions involved, the hospital refused to authorize the removal of the feeding tube without a court order. The Cruzans, with the assistance of the American Civil Liberties Union and Bill Colby, a young lawyer with a large Kansas City law firm, petitioned the local probate court to appoint Joe and Joyce as guardians for Nancy and to authorize them to remove the feeding tube. The Attorney General of Missouri intervened in opposition to the request, and the case ultimately ended up in the Missouri Supreme Court. That court ruled that because there was not clear and convincing evidence of what Nancy would want, the Cruzans could not remove the feeding tube. The Cruzans appealed to the United States Supreme Court, which agreed to hear the case. In a 5-4 decision, the Supreme Court held, the U.S. Supreme Court held, that while Nancy, through her guardian, did have the right to refuse unwanted medical treatment, including the feeding tube, the state of Missouri had the right to impose a higher evidentiary standard, what we lawyers would call clear and convincing evidence, in deciding what Nancy would have wanted. This, while on the face of it seeming like a defeat, actually provided an opening to the Cruzans when two acquaintances of Nancy approached them with information about conversations they had had with Nancy that she would not want to continue living in her current condition. Joe and Joyce returned to court with the new evidence, and the trial judge again ordered removal of the feeding tube. This time nobody appealed, and she died early in the morning of December 26, 1990. Now, from a legal point of view, the basic problem in the Cruzan and Quinlan cases is that there were no specific proof from Nancy or Karen Ann as to what they would want in such dire medical circumstances. As a result of these cases, many states, including Wisconsin, passed legislation setting forth legal documents that could be used to either make decisions in advance, what are called sometimes living wills, or appointing a decision maker to act in the event of incapacity, so-called powers of attorney for health care. Now, while the legislation theoretically solved the legal problems, it did not solve the practical and ethical religious problems of medical decision-making in the end-of-life context. One of the most contentious ethical and moral issues of our day have been the dual questions of when life begins and when it ends. The issue concerning the beginning of life has arisen in the debate over abortion. Arguments have been made in many quarters that life begins at conception, or even at the time that the egg is fertilized by the sperm. And certainly, given the advances in medical technology that allow prematurely born infants to survive outside of the womb at younger and younger gestational ages, albeit in many cases with severe physical and mental limitations, it has become more and more difficult to pinpoint when the fetus is viable, which has been an oft-applied legal test for the beginning of life. But as we've discussed, in recent years, the time of the end of life has become equally difficult to determine. In the past, a person was dead when he or she was dead. The heart stopped beating and the person stopped breathing. However, today, with all of our new technology, we can often restart a stopped heart and the person can return to normal life. However, we can also artificially prolong periods breathing for a seemingly indefinite period of time, even where there's absolutely no other brain function. And then there are those situations where respiration and heartbeat continue on their own, but there's no discernible cognitive activity. In these situations, what does it mean to be alive? And this is further complicated by other developments in medical technology, especially the common practice of organ transplants and particularly heart transplants. When is a potential donor dead for purposes of harvesting his or her organs? If someone's heart is beating and he or she is breathing but there is no other brain activity, is it ethical to turn off the machines that are artificially supporting life so that the transplant can move forward before the organs are no longer suitable? These are troubling questions for families and hospitals alike. In cases like this, many look to their religious faith for guidance. In 2013, the Pew Research on Religion and Public Life Project published a study of the views of all the major religious traditions, Christian and non-Christian alike. While they followed almost unanimous opposition to physician-assisted suicide with the United Church of Christ and Unitarian Universalists, feeling that this decision is best left to the patient and the doctor, there seemed to be more consensus on issues relating to withdrawal of life-sustaining treatment, even if such withdrawal would result in death. On the more general question of refusal of life-sustaining treatment, there appears to be a general accord that persons are not obligated to accept extraordinary treatment to prolong life at all costs. While different traditions articulate this view in different language, they all seem to differentiate between action or inaction that will not prolong life versus that which would hasten death. Again, the UCC and the Unitarian Universalists seem to hold a more open view. And there is less consensus about what is meant by extraordinary treatment, at least as far as the withdrawal of tube feeding is concerned. To be sure, medical profession and the courts have pretty much agreed that tube feeding is a medical procedure, in the same sense that supporting respiration using a ventilator is a medical procedure. However, there's an emotional component in the withdrawal of artificial nutrition and hydration. That was the issue that was at the heart of the Cruzan case. The Quinlan case was simply, if you could put it as simply, about turning off the ventilator. After the vent was withdrawn, Karen Ann continued to breathe on her own and was kept alive with the feeding tube for over 10 years. However, the Cruzan and the Chiago cases, as well as the NMF case here in Wisconsin, all involved the removal of a feeding tube, and they all stirred up more controversy. For some persons, removal of a feeding tube conjures up images of concentration camp survivors and starving children in third world countries. It is assumed that if the feeding tube is withdrawn, the person will die in agony. In point of fact, most of the palliative care medical literature suggests that the withdrawing artificial nutrition and hydration at the end of life will not cause significant pain or discomfort, as long as, for example, moisture is provided on the lips or the inside of the mouth, since the body itself generates pain-numbing ketones as part of the dying process. It is common for persons to stop eating and taking in fluids as the end of life approaches. And in fact, sometimes the use of the feeding tube can cause pneumonia. Yet in many cases, Wisconsin included, feeding tubes may not be withdrawn from non-decisional individuals without clear evidence of their wishes. In Wisconsin, in order to withhold or remove a feeding tube under the terms of an advanced medical directive, living will, or a power of attorney, the document itself must contain explicit directions about feeding tubes. And so that brings us to the final issue, the one raised by the story of Stephen and Jane. In recent years, there's been significant progress in persuading people to sign advanced medical directives, especially powers of attorney for healthcare. I have seen this during my years of practice, since it encompassed both the period before powers of attorney and afterwards. Under the Patient Self-Determination Act, and upon admission to a hospital or a nursing home, the facility is required to ask if the admittee has an advance directive, and if not, offer to prepare one for him or her, although execution of the document cannot be required as a condition of admission. However, as the story demonstrates, signing the document really is not enough, at least as it relates to the power of attorney for healthcare. The theory behind the power of attorney for healthcare is one is appointing an agent to speak for you when you no longer have the mental capacity to do so yourself. Now that's fine in theory, but as the story demonstrated, it only really works if your agent knows what you want. However, if you get into a situation where the agent doesn't know what is wanted, then we have the dilemma that faced Stephen in this story. Thus, it's imperative that there be a conversation among the principal, that's the person signing the document, the agent, the person who's going to make the decisions, and ideally other family members or significant persons regarding the principal's views and values related to health care, both during life and at the end of life. Remember that these powers of attorney are not just about end-of-life decisions. Because of issues related to Alzheimer's disease or other dementias and the after effects of strokes and other traumatic brain injury, there could be extensive periods of time when one may be physically alive, but nonetheless incapable of making medical decisions of any kind, from the most mundane to the most complicated. One of the questions that arises is who should be selected as an agent. Now, while the agent legally can be pretty much anyone other than your healthcare provider, I suggest there may be some other considerations. Is the person you're selecting someone who shares your views and values related to healthcare or respects you enough to carry out your wishes even if they disagree with them? Is this a person who is able to make tough decisions in stressful circumstances? Is this a person who is tough enough to be a strong advocate for you in dealing with the healthcare system? And of course, is the chosen individual willing to act as agent? How many of you out here know that somebody else has named you as a healthcare agent? How many of you younger people know whether your parents have put you down for sure? Okay. I've always been concerned that it's going to be the phone call of the young adult that finds out too late that mom or dad has made them the alternate agent on the healthcare power of attorney and one of the spouses is not available. But those are, to me, the basic criteria. Now, once you get beyond those basics, then familial relationships, vocation, and medical knowledge can be considered. But I believe the factors I've listed are considered the most important. In thinking about healthcare decisions for yourself, there's other factors to consider as well. Your current age and state of health. Nancy Cruzan, for example, was in perfectly fine health and when she had her accident. Her decisions would be different from an 85-year-old with cancer and early dementia. In your current state of health, what would be your goals of care? What are your personal, spiritual, and religious views, and how does that impact healthcare decision-making for you? What is important to you in your life? What abilities, if lost, could make continuing to live less important to you? How would you want your pain managed? What would be most important, pain control or your ability to interact with your friends and families? These questions could go on. And this is not a one-time discussion. Your wishes will change as you age and your health changes. I'm sure that many of you have already signed an advanced medical directive, but have you had the conversation? When? What did you discuss? Have you had the discussion with loved ones who are not among the designated decision makers? Is it time for another conversation to update your wishes? While it's easy to put off the discussion, as both Jane and Nancy Cruzan demonstrated, you can never be sure when the time will come that someone will need to make crucial decisions on your behalf. While this is not an easy discussion, nothing important is easy. There are people who can help you with this conversation, so please consider the conversation. And so, like I say, following this service, after we've had a chance to have some fellowship time, if anybody would like to join to begin this conversation, please come back over here to the main part of the sanctuary. So,